Caribbean connection. Tell them. Zaga. Rasta Zan. This is Beanie Man. Zaga. Jamaican, Puerto Rican connection.
CPL 722. All juvenile offenders and adolescent offenders shall be notified of availability of services through who?
The local probation department.
Number 2, services shall include the ability to conduct
A risk and needs assessment.
in order to help determine suitable and individualized programming referrals. Number 3, participation in risk and needs assessment shall be mandatory. Is that true or false?
That is false. It's voluntary.
Number 4, based upon the assessment findings, who shall refer the juvenile or adolescent offender to available and appropriate services?
The probation department. Yep.
Number 5, nothing shall preclude the probation department and juvenile or adolescent offender from entering into a voluntary service plan. Such service plan may include
Alcohol and substance abuse treatment and mental health treatment.
and services. 6, when preparing a
Pre-sentence investigation report.
of any juvenile or adolescent offender, the probation department shall incorporate a summary of any assessment findings and referrals and progress with respect to mitigating risk and addressing any identified needs. That's a pre-sentence investigation report.
When preparing a pre-sentence investigation report of any juvenile or adolescent offender from entering into a voluntary service plan, it may include an alcohol and substance abuse treatment plan or a mental health treatment plan and services. And basically, this is meant to find out what can be done to mitigate the risk and address any identified needs.
7, probation service shall not transmit or communicate to the district attorney or youth part any statement made by the juvenile offender or adolescent offender to the probation officer. However, the probation service may make a recommendation regarding the completion of his case plan to the youth part and provide such information as it shall deem relevant. Mary, what do you think of that?
That is true.
8, no statement made to probation services may be admitted into evidence at a fact-finding hearing at any time
Prior to conviction.
Number 9, the fucking chief administrator is hereby directed to establish in a superior court in each county a youth part of the superior court. Would you like to add anything to that, Mary?
That means that there's 62 youth parts because there's 62 counties in New York. Yeah.
10, judges presiding in the youth part shall be
Family judges. 11, judges shall receive training in
juvenile justice, adolescent development, custody and care of youths, and effective treatment methods for reducing unlawful conduct of youths.
Yes.
Hey, Mary, what kind of jurisdiction does the youth part have over proceedings in relations to juvenile and adolescent offenders?
They have exclusive jurisdiction.
13, the fucking chief administrator shall direct the presiding justice of the appellate division to designate magistrates. And what is the purpose of the appellate division designating magistrates? Why, Mary? I don't know what that could be for.
It's to act in place of the youth parts for certain first appearances. Yeah.
Go.
A judge authorized to preside as a magistrate shall receive training
in specialized areas, including but not limited to juvenile justice, adolescent development, custody and care of youths, and effective treatment methods for reducing unlawful conduct of youths. And by the way, that training that the magistrates get is the same as what the judges receive. 15, Mary, we have a juvenile offender or an adolescent offender that's going to be arraigned before the youth part, and the youth part is not in session. What shall we do?
bring him before the most accessible magistrate to be arraigned and for the purpose of seeing whether he'll be detained.
16. If the defendant is detained, he shall be brought before
the next session of the youth part. Okay. 17. If the youth is not detained, he shall be ordered to appear where?
before the next session of the youth part, Mary. 18.
Okay.
If the defendant waives a hearing upon a felony complaint, the court must do what, Mary?
Order he be held for the action of the grand jury.
20. Juvenile offenders, 13, 14, and 15, bad stuff, bad little kids. If there is a hearing, at the conclusion of the hearing, the youth part must dispose the felony complaint as follows. If there is reasonable cause to believe that the little kid, I don't want to call him anything bad, committed a crime which a person under 16 would be criminally responsible for, the court must do what to him?
Order he be held for the action of the grand jury.
21. Now we're talking about adolescent offenders who are 16. If there is a hearing, at the conclusion of the hearing, the youth part must dispose of the felony complaint as follows. If there is reasonable cause to believe the defendant committed a
Felony.
the court must order the defendant held for the action of the grand jury. 22. Back to juvenile offenders, 13, 14, 15-year-olds. If there is not reasonable cause to believe that the defendant committed a
Crime.
which a person under 16 would be criminally responsible for, but reasonable cause to believe the defendant is a juvenile delinquent, which is 7 to 16, not bad stuff, the court must
Direct the action be removed to family court.
action. 23. Back to adolescent offenders, which are 16 felonies. If not reasonable cause to believe the defendant committed a
Felony.
but reasonable cause to believe that the defendant is a juvenile delinquent, 7 to 16, not bad stuff, the court must
Order the action be removed to the family court.
Oh.
If there is not reasonable cause to believe defendant committed any criminal act, the court must do what, Ange?
They must either they have to dismiss the felony complaint, they have to discharge the defendant from custody, and they have to exonerate his bail.
When a motion for the removal by defendant is denied, what happens to the juvenile offender?
Well, if that motion is denied, Mary, no further motion may be made by that juvenile offender with respect to the same offenses.
Motion for removal is granted, what happens?
Well, Mary, if that motion by the juvenile offender is granted, then there shall be no further proceedings against the juvenile offender in any local or superior criminal court, including the youth part of the superior court, for the offenses which are the subject of the removal. 32. Back to adolescent offenders, 16 years old with a felony, where the defendant is charged with a felony, other than what, Mary?
1. Class A felony. 2. Violent felony. 3. Juvenile offender felony. Really bad shit.
Then, if the defendant is charged with a felony other than those three that Mary just mentioned, the court shall, upon notice from the district attorney that he will not file a motion to prevent the removal, order the transfer of the action against the adolescent offender to the family court. The court shall, upon notice from the district attorney that he will not file a motion to prevent the removal, order the transfer of the action against the adolescent offender to the family court. 33. This is when the DA requests to remove to family court. The court shall, at the district attorney's request, order removal of the action against an adolescent offender to the family court where the defendant is charged with an offense other than
1. Class A felony other than a drug felony. 2. Violent felony. 3. JO felony. Or 4. A VTL.
and they will order it removed to the family court upon consideration of the criteria. It is determined that to do so would be in the interest of justice.
Yeah. So basically, this list of 4 is talking about when the DA requests removal to family court, the court doesn't even have discretion. The court shall order removal. The only time that the court doesn't have to do it is when the defendant is charged with one of those four things I just said.
However, Mary, where the felony complaint charges the adolescent offender with murder 2, rape 1, criminal sexual acts 1, or an armed felony, a determination to remove to the family court shall in addition be based upon findings of one or more factors. 1, mitigating circumstances on the manner the crime was committed. 2, if the defendant was not the sole participant in the crime, whether the defendant's participation was relatively minor, although not so minor to constitute a defense. And 3, possible deficiencies in the proof of crime.
Yeah. So, however, basically this is still talking about the request of the DA. But when the kid is charged with murder, rape in the first, crim sex act in the first, or an armed felony, and that's MARC, M-A-R-C, murder, armed felony, rape in the first, crim sex act in the first, the determination to send it to family court has to be based on one of these three things. 1, mitigating circumstances. 2, not sole participant, role minor. And 3, possible deficiencies in the proof. Okay.
34. This is back to juvenile offenders, 13, 14, and 15. Bad stuff. Bad kids. After motion of a juvenile offender or after arraignment on indictment, the court may, either on their own motion, on the district attorney's motion, or on the defendant's motion, order the removal to the family court. If, after consideration, the court determined to do so, would be why, Mary?
In the interest of justice.
Or they can order the removal of the action involving an indictment to the family court, charging a juvenile offender with murder 2, rape 1, criminal sex acts 1, or armed felony. But you need the consent of who, Mary?
The district attorney.
And if the court finds one or more of the following factors, either mitigating circumstances on the manner the crime was committed, or if the defendant was not the sole participant in the crime and the defendant participation was relatively minor, although not so minor to constitute a defense, or possible deficiencies in the proof of crime, and after consideration of the factors, the court determined that removal of the action to the family court would be
in the interest of justice. Yeah. So, Angela, what makes it in the interest of justice is determining one of these following things. And the court has to the extent possible, examine individually and collectively the following.
A, the seriousness and circumstances of the offense. B, the extent of harm caused by the offense. C, the evidence of guilt, whether admissible in court or inadmissible at the trial. D, the history, character, and condition of the defendant. E, the purpose and effect of imposing upon the defendant a sentence authorized. F, the impact of removal to the family court on the safety and welfare of the community. G, the impact of the removal to the family court upon the confidence of the public. H, the attitude of the complainant or the victim with respect to the motion. And last, I, other relevant facts indicating that the judgment of conviction would serve no purpose.
Yeah. Out of that list of 9 that Angela just read, my favorite one is other relevant facts indicating that a judgment of conviction would serve no useful purpose. Okay.
36. Following arraignment of a defendant charged with a crime committed at 16, that's an adolescent offender, other than a Class A felony except for A, a violent felony, B, a juvenile offender felony, or C, a VTL offense, the court shall order removal to the family court unless, within 30 calendar days of arraignment, the district attorney makes a motion to prevent removal, and if the defendant fails to report to the probation department as directed, the 30-day time, it shall be told until such time as he reports to the probation department.
Basically what this is saying, it's similar to question 32 that we did before. In question 32, the DA actually stated he was going to make a motion. He wasn't going to make a motion to prevent removal. But in this question, the DA just doesn't bother to make a motion. The result is the same. The action has to be sent to family court unless the DA either makes this motion to prevent removal within 30 calendar days or within 30 days of defendant reporting to probation.
37. If the DA makes a motion to prevent removal, it shall be in writing upon
prompt notice to the defendant.
38, motion shall contain allegations of sworn fact based upon
personal knowledge.
39 says the motion shall indicate if the district attorney is requesting a hearing. 40, the DA's motion to prevent removal shall be heard,
Promptly.
and the defendant shall be given an opportunity to reply to the motion, and
The defendant, and 42, the defendant shall be granted any reasonable request for a delay.
43, either party may request a hearing on the facts alleged in the motion to prevent the removal, and the hearing shall be heard
Expeditiously. The court shall deny the motion to prevent removal unless the court makes a determination that extraordinary circumstances exist to prevent removal of the action to family court.
45, the court shall make the determination on the motion to prevent the removal in writing or on the record within
five days after the hearing or submission of defense, whichever occurs last. So, baby Tanya Harding, she wants to go to family court, but DA, me, makes a motion to prevent the removal. I want a hearing, or she wants a hearing. So we have a hearing, and the court must make a determination on this motion within 5 days of the conclusion of the hearing. But if, let's say, nobody requested a hearing, then the court has to make their decision within 5 days of baby Tanya Harding's opposition to my motion to prevent removal to family court.
46, the court may order removal to the family court where all the parties agree, and 47, there shall be a presumption against custody, and case planning services shall be made available to the defendant. So this is saying that there is a presumption against custody, and that the case planning services shall be made available to the defendant, so they don't want to put the kid in jail, pretty much. That's what it's saying. 48, upon arraignment of a defendant charged with a crime committed when he was 16, that's an adolescent offender, charged with a Class A felony other than a controlled substance or a violent felony, the court shall schedule an appearance no later than 6 calendar days from the arraignment for the purpose of reviewing the accusatory instrument, and the court shall notify the district attorney and the defendant regarding the purpose of such appearance.
So basically what this is saying is that we're talking about the most serious charges that an adolescent offender can have, which is a Class A felony besides a drug felony. So the regular Class A felonies like murder, arson in the first degree, or a violent felony offense, which would be like rape in the first degree. When the kid is charged with those type of really serious shit, they want that case in front of the youth part within 6 calendar days from arraignment so that the youth part judge can take a look at the case and make sure that this is a legitimate charge. This person really is either in danger or he just got caught up with the wrong crowd, and we got to figure out if this is being overcharged or if this is really serious shit. And that's why it's important that it's within 6 calendar days of arraignment. And at this appearance, basically, they're still going to send the case to family court unless the DA can prove that the defendant caused significant physical injury, engaged in unlawful sexual conduct, or displayed a rifle, shotgun, or deadly weapon. And if he really did one of those things, the DA is going to be able to prove this. So then the case won't go to family court.
And 49, upon such appearance, the court shall review the accusatory instrument and any relevant facts for the purpose of making a determination. And 50, the court shall order the action to proceed in accordance with 72223, unless after reviewing the papers and hearing the parties, the court determines in writing that the district attorney proved by a preponderance of the evidence one or more of the following. 1, the defendant caused significant physical injury to a person other than a participant in the offense. 2, the defendant displayed a firearm, shotgun, rifle, or deadly weapon. Or 3, the defendant unlawfully engaged in sexual intercourse, oral sexual conduct, anal sexual conduct, or sexual contact.
Key points here before I sign off are 1, family court judges. Youth part judges are supposed to be family court judges. 2, accessible magistrates for certain first appearances. The next important thing is, I think, the time rules in 722.723. There are 5 of them. The first one is 30 calendar days for the DA's motion to prevent removal. The next one is prompt notice for the motion, and promptly motion is returnable promptly. Next one is the hearing has to be held expeditiously. Then we go to the 5 and 6 day rules. 5-day rule is the judge's decision on the motion to prevent removal, and the 6 days is for that really, really bad shit that they gotta have court appearance in the youth part within 6 calendar days so the judge can review the accusatory instrument. That's what I think is important. And what do you think is important?
I think it's important that we really have a good time and go on vacation after this test. And drink and have party and forget all about this crap.
Yeah, I could go with that.
All right, signing off. Bye.